may be seated. Thank you. Well, welcome to today's session of the Kansas Court of Appeals at Johnson County Community College. We are really thrilled to be here today. Our court has 14 judges, and we generally, every month, we have dockets every month and try to travel around the state as much as we can. We have a panel at Washburn Law School today. We have a panel in Wichita at the Wichita Federal Courthouse. We have had dockets in as far as Colby and Pittsburgh, you name it. We try to travel around to give students and members of the public an opportunity to see the court in action and to ask questions. So we are very happy to be here today. I am particularly happy to be here today because I went to this wonderful college out of high school at Shawnee Mission North High School, and then came here before I went on to KU. My husband is also here today, and he was also a Johnson County Community College associate's degree graduate, played on the baseball team here. So we have a lot of connections to this school. With me today, to my right, is the senior judge on our panel, Judge Joseph Perrin. Judge Perrin was a district judge in Johnson County for many years before he got on the Court of Appeals, and he is the longest-serving judge on our court and among the longest-serving judges in the state of Kansas. To my left is Judge Tom Malone. Judge Malone, before he came on our court, was a district judge in Sedgwick County, so he has many years of judicial experience as well. With that, we are going to call the docket today, or start the cases today. We have 3 cases set for this morning. I think you got a little summary of them in the school. Students got a little summary of them, and I think you may have even gotten the briefs. Yes, Glenda is saying yes, you got the briefs. So, counsel, you've got not only a hot court, you've got a hot room here today. They know everything about your case. So I think it's a great learning opportunity to see how a case ends up getting argued before our court and discussions of what happened in the trial level. After the cases are concluded, we will be happy to answer any questions any of you have. The only downside is we cannot answer any questions about the exact cases you've heard, not hypothetically, not otherwise. We cannot discuss those cases, but we can discuss anything else about the procedure of our court or anything you want to know. All right, for the attorneys that are appearing today, I ask that if you are the appellant, you let me know how much time you want to reserve for rebuttal. For those present in the audience, each side gets 15 minutes to argue, and the appellant can reserve time for rebuttal if they wish, although the appellee cannot. So they'll be letting me know at the beginning how much time, if any, they want to reserve for rebuttal. I have my cell phone here on which I will be keeping time because I recalled right, there's not a clock in here that I can see. So if you see me looking down at my phone, I'm not texting or doing other business. I'm trying to keep track of the time. The judges will be asking questions throughout the oral argument. I'd also ask, we generally ask that the parties not waste their 15 minutes really going over the facts of the case because we're very familiar with the facts. But in this case, if the appellant wants to take a couple minutes to go over the facts, that's fine, and I won't count that against your time, but no more than a minute or two, okay? So with that, we'll call the first case of the day. If the parties would step forward on State of Kansas versus Scotty Lindsay and announce who's here today.
Good morning, Your Honors. Corinne Gunning appearing on behalf of Scotty Lindsay, the appellant.
Okay.
And on behalf of the state of Kansas, Ethan Ziff-Sigler from the Wyandotte County District Attorney's Office.
Okay, Ethan Ziegler.
Ziff-Sigler, ZIPF-SIGLER.
And are you on the brief?
I am not on the brief.
Okay, so I need your bar number.
It's 24220.
And the first name was?
Ethan.
Ethan, right. Okay. All right, and did you wish to reserve any time for rebuttal?
Yes, I would like to reserve 3 minutes, please.
Okay, is that, can you all hear her back there, or is her microphone on, or?
It appears to be on.
Need to get it just closer.
Move closer to me. Is that better? That sounds better.
You're probably gonna have to lean into it a little bit, I'm sorry.
It's okay. This is my first experience with a microphone like this, so.
Okay, thank you, I think that's better. I can hear
Okay.
her better, I don't know about everybody else. Okay. So you said how long, 3 minutes?
3 minutes,
Okay,
please.
you've got it.
All right, I did raise several issues in the brief, and I'm prepared to discuss each of them based on the interests of the court. I will start with issues 1 and 2 on the limitation of cross-examination, and then, if time permits, move to 3 and 4 regarding the motion for new trial. And I will simply let issue 5, the cumulative error issue, stand on the brief. I will give a brief factual background. Lamont Boyd was shot in this case, and he identified Michael Wright and someone he knew as Scott K.C. as the shooters. And at the same location, Melinda Bates Fuller was also shot and killed at the same time. Michael Wright was ultimately picked up by the police while he was breaking into cars and identified someone he knew as A1 as the shooter and indicated that someone named Brandy Strobel was also present in the shooting. Police ultimately went to Brandy Strobel's house where they located my client, Scotty Lindsay, and arrested him. They also searched the house for evidence related to the shooting and did locate a gun at the house. Ultimately, Scotty was charged with premeditated first-degree murder of Melinda and attempted premeditated first-degree murder of Lamont, as well as criminal possession of a firearm by a convicted felon. Ultimately, a jury convicted Scotty of second-degree murder of Melinda and attempted second-degree murder of Lamont, as well as the criminal possession of a firearm by a convicted felon. And the district court sentenced him to 688 months in prison. For the reasons I have stated in my brief and to be argued today, I would request this court reverse Mr. Lindsay's convictions and remand for a new trial, or in the alternative, remand for a new motion for new trial hearing with conflict-free counsel. I have joined issues 1 and 2 because they both relate to the limited cross-examination of Amber Pavlich. First, I argue that this limitation by the district court violated Mr. Lindsay's right to present a defense. And then second, that the court's sua sponte limitation of cross-examination constituted judicial misconduct.
Counsel,
Go ahead, no, you go ahead.
Counsel, what admissible evidence could she have provided the finders of fact? It seems like she was being asked for her opinion on guilt or innocence, which is generally something we do not allow someone to testify to.
As I argued in the brief, and from my perspective, what she had testified to is what she had already communicated to Scotty, is that she had this belief that he did not have a gun, and that the charges were, in her words, bullshit, and that she did not believe that he had shot those two people. What was limited, I'm sorry, Judge.
Yeah, I'm sorry to interrupt you, but why should we care what her opinion was as to guilt or innocence? I mean, you can present evidence on facts that occurred, but asking someone or allowing someone to testify as to whether they think this person is guilty or not is not something that we would generally allow a witness to testify to.
Correct, yes. And she had already testified as to her opinion. What had happened is that the state, during their direct examination, discussed about her relationship with Scotty and her knowledge of him as a person and his character and things like that. And so what defense counsel argued was that they were getting to the point where they were asking her why she believed he did not have a gun, why she believed he was not present at the shooting. What was it about her relationship with Scotty, her knowledge of him as a person, or what other evidence she had to support her belief that he was not present or that he did not have the gun. And so it was the facts supporting her opinion that was limited. Her opinion got in, the facts supporting it did not.
Well, the opinion got in, and then the judge immediately shut it down. And he has a responsibility under case law to to control the proceedings of the trial, and we have cases that say when that sort of evidence comes in, he has a responsibility as the judge, sua sponte, to take action to prevent that kind of evidence from coming in. Isn't that correct?
I understand there is case law. I believe there is conflicting case law, which I have cited in my brief, that a judge it is actually the state's responsibility to object if they find that evidence objectionable. And in this case, the state did not object and explained that their reasons for not objecting is that they wanted that evidence in because
They thought that would open the door for allow them to bring in evidence of his prior
Correct.
homicide charge.
And so in this case, my opinion, and I guess my opinion doesn't matter, but what I briefed is that the judge took the state's position and advocated on the state's behalf to leave that evidence out, even after the defense counsel did explain that he wanted to get in actual evidence and actual facts to support her beliefs. The judge still
And he
decided
didn't
not
proffer
to.
that to the court. He didn't present a proffer of what evidence he was trying to get in, correct?
Not specific facts, but simply the
And
the
if
general.
her evidence was, from reading the transcript, it looks like she may have been ready to say that she was with him kind of almost an alibi sort of witness, that she was with him and he couldn't have been at the location at the time or whatever. Defense counsel could have asked all of those questions about where she was at the time of the incident and if she knew where he was. It was the point of saying, I don't believe he's guilty, and this is why I don't believe he's guilty, that crossed the line. Don't you think? Why isn't that where the line was crossed?
And I mean, that is what was asked and answered. And again, you're correct. There is no proffer in the record of what exactly he was going to ask and what exactly she was going to say in response to those. He simply indicated that he was going to continue forward and get unobjectionable evidence in, and the court simply cut him off and said, "We're not going anywhere near that anymore." And so I do believe that there are limitations on the court introducing themselves as what I would characterize as an advocate in this case. Yes, they do have an obligation to enforce the rules of evidence, but case law is also very clear that it is the party's obligation to object and the court's obligation to rule on those. And typically, the Supreme Court has found that it's not proper for the court to introduce themselves in the manner that the court did in this case. Because if there are no further questions on those first two issues, I think that I would just say that the limitation of the cross-examination did limit Scotty's right to present a defense because his defense was complete innocence, and it was the defense counsel's argument that her testimony did go to that defense. And so I believe that it deprived the jury of the ability to review all the evidence in the case to make a finding on Scotty's guilt. And I also believe that everything sought from Amber in this case did have direct bearing on that. And so if this court does find judicial misconduct, that is not harmless because it does go directly to his defense and claim of actual innocence, and so it would actually have bearing on the case. Without further questions, I will move on to issue 3 and 4, which I again combined because they both relate to the motion for new trial. First, his claim that his defense counsel was ineffective, and then the court's failure to appoint conflict-free counsel upon the clear delineation, showing that his counsel was conflicted because of the allegation of ineffective assistance of counsel. Specifically, the alleged defense counsel error was the failure to object to Brandy Strobel's recorded statement. She testified in this case and made several statements indicating that she did not see Scotty with a gun. She had no recollection of IDing Mr. Wright. She did not hear gunshots at the time. Again, she was present at the shooting, according to Mr. Wright, and that her recorded statement contradicted all of those things. She testified differently from her recorded statement and was released by the state as a witness and was not planned to be recalled.
I have a couple questions. One, the defense had the recorded statement ahead of time. The recorded statement was no surprise or anything to the defense.
Correct.
The defense knew about the recorded statement. And during Ms. Strobel's direct examination by the prosecutor, she was confronted 4 or 5 times with the transcript of the recorded statement saying, look at that and see if that doesn't refresh your memory. Because in her, and I'm saying this for the benefit of the group here, because in her recorded statement, she said that she saw Mr. Lindsay with the gun. After the first gunshot, she saw Mikey run out. And then Mikey was running outside when she heard the third gunshot, or the second gunshot, which would clearly place Mr. Lindsay as the shooter of the individual up in the bedroom, the one that was killed. In her trial testimony then, she indicated that she never saw a gun, she never heard any gunshots, and so she was confronted several times with that. So she was confronted with that. The defense attorney had the right to cross-examine her about that, about the inconsistencies in the statements that the prosecutor was trying to elicit. And then during the defense attorney's cross-examination, he did ask her about evidence that was only obtained from that interview. He said, did Mikey have the hood pulled up over his head, and did he jump into the back seat? And she said yes. And the only place that information had ever appeared at that point was in the recorded interview. So wasn't that an adequate opportunity to cross-examine about everything in that recorded interview? Why was that not sufficient? Why was it then error to introduce the audio recording when they'd already been discussing it with her and he'd had a chance to talk to her about those things?
Well, I guess my response would be that the recorded statement still remains hearsay. And the introduction of hearsay is not allowed. And the transcript of, to my recollection, and you or opposing counsel can contradict me if I'm incorrect. To my recollection, the transcript of the recorded statement did not come in as evidence. It was the recorded statement itself that came in as evidence for the jury to have. And they did not read the transcript verbatim. They picked and chose certain things. And so I think that the piece of evidence itself, and she obviously said more than just the things that they picked and chose. And so I think that the opportunity to cross-examine on the entire piece of evidence, the entire interview, is important. And I also just would say the state released her knowing that they wanted to get that piece of evidence in. And so they got that piece of evidence in without any opportunity to actually cross-examine the witness about the full piece of evidence. And so defense counsel did have the opportunity to cross-examine about the pieces and parts, but not to cross-examine about the whole. And so...
Well, counsel would have been able to do that, wouldn't he? Wouldn't couldn't he call her as a witness?
He could, but it's not his obligation to do so. And so, I mean, and I guess if he hadn't, obviously, if you think that he should have called her.
No, I'm not saying whether he should or should not. It's just that didn't he have the opportunity, if he so chose, to recall her and testify on behalf of his client?
He did, but the defense has no obligation to present any witnesses. And so the state got a piece of evidence in that was hearsay without the opportunity to cross-examine on that piece of evidence, and then you would shift the burden to the defense counsel to sort of call a witness on their behalf to rebut that.
You're
Thank
heading
you.
into your rebuttal time.
And so I guess I would just say that his counsel was ineffective by failing to object to that statement. And the court was also incorrect in failing to appoint conflict-free counsel upon his admission that he had failed to object to inadmissible hearsay.
Thank you. We'll await anything else in rebuttal. Ready?
May it please the court, I'm Ethan Ziv-Sigler on behalf of the Wyandotte County District Attorney's Office for the Appellee. I am going to maybe over-explain a few things. I know your honors know most of this, but just because we have an audience, I might
That's fine.
be a little over-explanatory. Let's imagine a world in which a prosecutor and a defense counsel hate each other. They are petty, they dislike each other immensely, but they personally and independently have decided that the best way to handle this is to be extremely petty at trial. They ask questions they know are illegal, they elicit information they know is inadmissible, but neither objects because they know they're getting petty, foolish answers out of witnesses and they're attacking each other. Is the judge required, because neither of them object, to let his trial become a circus? And the answer is, I believe, no. Judges are tasked with controlling the courtroom, and that includes controlling the information that comes in, sometimes without an objection. And that is because a judge is not there as a passive observer, they are there as an arbiter of what is supposed to be admitted. They do not have to let their trial become a circus. They do not have to let clearly illegal evidence in just because it hasn't been objected to. They can control the courtroom, and the case law is clear that a judge has not only the ability but the duty to maintain a controlled courtroom. In this case, the real threshold question is, did Judge Grosko err in not allowing inadmissible and illegal evidence in? And the answer is simply no. If the state, if we take it on the other way, the state had a detective on the stand and they said, "Detective, do you believe the defendant is guilty?" The judge does not have to wait for the defense attorney to stand up. The judge can say, "I know the answer to this question and will draw a mistrial. In the interest of judicial economy, I'm going to cut that detective off before he can even answer it." And if I'm the prosecutor, I might even get a call from the disciplinary administrator because we know that that question is not admissible. You're not allowed to ask a witness, "Do you think the defendant is guilty?" When we're breaking down whether or not this case is reversible, the threshold question is it structural error? If it's structural error, that basically means it's a constitutional error of such magnitude that we don't even ask if the error was harmless, it just automatically reverses. And in this case, it's clear from the case law this is not structural error. In Kansas, judges are allowed to ask questions. They are, in certain circumstances, even allowed to exclude evidence sua sponte, or on their own. Because judges are allowed to do that, the Court of Appeals then has to weigh, one, whether it was error what they did, and two, what was the effect of the error. And that means it's non-structural, which means the second question we get into is harmlessness. And really, this is where, even if the state concedes that Judge Grosko is wrong in his objection, the defense has not at any point articulated what harm was done from this objection. They haven't articulated what line of questioning was cut off. The single question that was cut off was, "Do you think the defendant is guilty?" That is not a relevant question. That is not an admissible question. So any other evidence that may have occurred from a further cross-examination has to be preserved in one of two ways. It has to be proffered to the court, or it has to be proffered even in a brief of, Mr. Sexton didn't say this, but there is a good faith basis to believe that there was additional evidence. And in this case, there simply wasn't. This has to deal with the cross-examination of a witness named Amber Pavlich. She was not an eyewitness at the scene, and she was not an alibi witness. So there's really no indication that there was any other questioning that could have occurred after Judge Grosko stopped that question that would have been beneficial to the defense attorney. So at this point, even if we were to concede that Judge Grosko telling Mike Sexton not to ask any further questions stopped him from going on. This court doesn't have the ability to weigh that versus the evidence that did come out and then determine that there was some harm in it. So the error is ultimately going to be harmless. But I don't think that Judge Grosco made a mistake. This is not an admissible question. You are not allowed to ask a witness their opinions on the ultimate determination of guilt or innocence. That's the sole province of the jury. So the first question, did it prevent a defense? No. There was simply no argument that there was more of a defense to be presented. And then the second question, did the judge fail to be an impartial jurist in this case? No. Again, this is an inadmissible question that the judge did not allow in, and there's no indication from the record that the judge belabored it, that the judge openly harangued or put the defense attorney on the spot in front of the jury to try to humiliate him. It was simply this is not allowed. Do you have anything else you want to ask? You're not allowed to ask this line of questioning. And because the judge did not make a big show of it, the judge did not try to humiliate the defense, the judge did not make any opinion as to guilt or innocence, the judge never became a partial or one-sided judge, and the defense was never denied due process of an impartial jurist. So that would be the state's arguments to 1 and 2. On the ineffective assistance of counsel, I'm going to slightly reverse the order and start with point 4, which is, was conflict counsel necessary? Generally, if in a motion for a new trial, ineffective assistance of counsel is argued, the court is supposed to appoint a second counsel, or what we call conflict counsel. That's because we just typically don't want defense attorneys having to argue their own ineffectiveness, because if you ask me if I'm a good attorney, generally I'm going to say, yes, I'm a very good attorney. So we ask that conflict counsel be appointed. In this case, though, it was just simply unnecessary. The sole issue of ineffective assistance of counsel was Mike Sexton ineffective for failing to keep out a recorded statement? That is a question that is solely a question of law, and in that case, there's really no reason for conflict counsel. The judge is in just as good a position as conflict counsel, me or your honors are now, to determine the admissibility of the recorded statement. So conflict counsel in this case wasn't necessary because the sole threshold question can be fully determined based on the record and is not necessary that we go into any sort of factual finding that would require an independent counsel to review the record.
And in this case, didn't counsel admit during argument on the motion for new trial that he should have objected to the admission of the recorded statement, and he didn't?
That's correct. And this is raised because Mr. Sexton, who was the defense attorney in this case, filed a post-conviction motion for new trial in which he said, I should have objected this to keep it out. So he had brought this issue to light in the first place. Going back from that then, since conflict counsel isn't necessary, the real question then becomes point 3, was Mr. Sexton ineffective for failing to object to this? And again, it's helpful to almost start from the ending. When we're talking about ineffective assistance of counsel, we talk about a case called Strickland. Strickland says that when we view ineffective assistance of counsel, we first ask, was the behavior of counsel below an ordinary standard of care? And then if we determine that it was, we have to ask, did counsel's behavior below a standard of care affect the outcome of the trial? And in this case, if we skip right to the end, even if you assume Mr. Sexton was ineffective, you really can't say that it affected the outcome of the trial, because even in a perfect world where Mr. Sexton objects to the admission of that evidence, the state has more than enough tools at its disposal to cure that inadmissibility, to cure the hearsay, and to ultimately allow the recorded statement in. So it doesn't have any impact on the trial, because even if Mr. Sexton stands up and says, I object, the state then has an arsenal of tools to get in the recorded statement anyways. A recorded statement is admissible for the purposes of impeachment. It's, in this case, it's admissible because Kansas uniquely has an exception, well, is one of those states which has an exception to hearsay, where if a witness is subject to cross-examination, you can get their out-of-court statements in. So again, this, aside from the fact that I would argue at trial the foundation was laid to allow this statement in even over the objection, so it wouldn't have made a difference, even if there was some defect in that the cross-examination wasn't full enough, if Mike stands up and says, I object, the state can still cure it. So at the end of the day, when the court is wondering, should this be reversible because this should have been taken care of at trial, ultimately what the court can say is, no, it would have made no difference because even with an objection, the state would have easily been able to cure any problem with the admissibility. The statement comes in anyways. The trial proceeds exactly as it proceeded in the real world, and so there is no reason to reverse. Finally, the defense argues cumulative error. That is that the multitude of errors during the trial deprive the defendant of a right to a fair trial. In this case, there is only one trial error alleged. That trial error is that the judge objected sua sponte, and that is going to be fully determinative of the cumulative error analysis. If you find there was no error, there can't be cumulative error. You can't accumulate a single error. I would argue that the ineffective assistance of counsel doesn't go to the cumulative nature, because cumulative error has to do with identifiable trial errors, not necessarily counsel errors. So in this case, because there was no error in Judge Grosco controlling his courtroom, because Mike Sexton, even if he objected, would not have been able to keep those statements out, there is no error that occurred in trial that has been identified here today, and the state would ask that you affirm the defendant's conviction.
Thank you very much. Any questions?
Thank you.
Okay, thank you. Give you a couple minutes.
Quite the presentation. First, I would say that in this case, there's no evidence of Mr. Ziegler's hypothetical of a circus that is happening in the courtroom. And if a police officer were asked, do you believe the defendant is guilty? I believe the court would say, don't ask that question. You can ask him reasons why he believes the defendant is guilty or not guilty, but you cannot ask the question of this. In this case, the question was, you wrote that you know he's not guilty of that, quote, bullshit, end quote. Is that what you wrote? And the court stopped that question, said, I'm not going to let that in. I don't know why the state's not objecting, but you can't get it in. And Mr. Sexton said, let me ask this, Your Honor. I was going to ask what facts she had of that. Am I allowed to do that? And the court said no. So the court cut off all questioning related to Amber's knowledge of why she believed that Mr. Lindsay was not guilty altogether. And
Counsel,
Are you saying that he can ask? He can't ask what her opinion is, but he can say, "What reasons do you have to believe that Mr. Lindsay is not guilty?" You think that's an acceptable question?
I wouldn't phrase it that way. If I were counsel, I believe the question would be more of, you investigated like with the police officer, you investigated this, what evidence did you find? You've known Mr. Lindsay for this long. Were you with, what were you doing? The questions that you were asking about. Can I ask about facts regarding why she believes this? But the court cut off all questioning altogether, and
because
so
the
Mr.
question was
Sexton
why. Tell us why you believe he's not guilty. I mean, it's
Right.
assuming
Right.
that she believes he's not guilty. So you're indirect. You may not be directly asking, although in this case you may not be directly asking what's your opinion, but you are certainly indirectly asking that.
I disagree. If you're asking of facts that support something, facts are evidence and they can come in, and I believe that that's what defense counsel was asking for in this case, is facts to support Mr. Lindsay's defense, not necessarily facts to support her claim, her opinion, but rather his claim defense of actual innocence. And I believe that that's the questions that, again, I lack a proffer, and so I recognize
Right.
that hurdle. But I believe that the court just cut off any concerns regarding this altogether, and I believe that that's why Mr. Sexton just simply sat down and said, well, I'm not going to get anything in, so I might as well, I guess judge has stopped me, and so any further inquiry of this witness is
You are out
fruitless.
of time. Is there any other questions? Thank you very much.
Thank you.
The court will take this matter under advisement and issue an opinion as quickly as possible. Thank you, counsel, for your arguments. The next case up is, just a moment here. Nathan Jarvis versus Kansas Department of Revenue. The parties state their appearances, please.
Please support Joanna Lobstida of the Kansas Department of Revenue.
Okay.
Please support Sheena Boyd for Appellee Nathan Jarvis.
Okay, and did the appellant wish to have any rebuttal time?
Yes, Your Honor, 3 minutes.
3
is
minutes,
requested, please.
okay. Whenever you're ready.
Thank you. Thank you. May it please the court, I'm Joanna Labastida. I'm representing the Kansas Department of Revenue. Just as a quick overview for the audience who may not know, when someone is accused of a DUI, there is a criminal proceeding, and then there is an administrative proceeding to potentially suspend their driver's license. They do have overlapping facts, of course, but they are different standards for the criminal side versus the civil side or the administrative side. In this case, the only issue that I raised before this court is whether the district court erred by granting the request to set aside the administrative order of suspension of the appellee's driver's license, Mr. Jarvis. 2 subsections to that issue, though. The first is that the district court erroneously found that the officer did not have reasonable suspicion to stop Mr. Jarvis's car in the first place. And then related to that, the district court erroneously held that the amendment to KSA 8-1020 subsection P, that the legislature had intended for constitutional issues to be decided.
Let me interrupt you for just a minute.
Yes.
The court clearly found that there was no reasonable basis to stop this vehicle.
That's right.
Okay. Do you have to have a reasonable basis to stop the vehicle in order to request a test?
I would argue that that plays into the overall.
Just a simple question. Do you have to, in order to request a breath test under the statute, it says, one or more tests may be required of a person when, at the time of the request, a law enforcement officer has probable cause to believe the person has committed a violation of the DUI law, and the person has been arrested or otherwise taken into custody for the violation of a state statute. So, does the fact that the judge clearly found that there was no basis to stop this vehicle, why doesn't that end the discussion right there? Because then if there was no basis to stop, there was no basis to request that he take a breath test.
That, with the case law, criminal case law being what it is, I would agree with that statement.
And I'm not talking about an exclusionary rule. I'm just talking about if there's no basis to stop, there's no basis to ask.
Right. Well, just with the argument being, the question what it is, our argument is that the court erroneously held that he did not have a basis to stop the vehicle. But I understand what your question is, and I would agree that the current state of case law, or even the statute as you read it, would require a basis to stop the vehicle.
And in this case, you argue that the judge was wrong in deciding that there was not a basis.
That is right.
But the judge based his decision pretty much entirely on the credibility of the officer and said, I don't believe anything he said. So, and we don't judge the credibility of witnesses on appeal. So what are we to do with that?
That is a difficult hurdle for us to overcome. I completely
Yeah, it's
understand.
very
that.
difficult.
Yes. And I was the attorney that tried this at district court as well. And I would have to agree that the officer's demeanor probably did not help his testimony. But
And that's why we don't reevaluate credibility, because that judge is there to see the officer's demeanor and to decide whether he or she is going to believe what the officer is saying. And in this case, the judge simply did not believe it.
I do take a slight issue with that overall finding by the court, because he did hold later on in his memorandum decision that once the officer stopped Mr. Jarvis and interacted with him after that, he would have found that there was reasonable grounds to request the evidentiary breath test. So I think the officer's demeanor at trial didn't help his testimony, but the facts that he was testifying to were eventually supported by his investigation later on. And unfortunately, he testified to things that happened before he started his in-car camera, and that would have supported the reasonable suspicion to stop the vehicle. And the video that occurred after he stopped, everything that happened after he started the video didn't necessarily support his testimony, but I would argue that the officer's testimony to what happened before the video should have been considered. But I think because of his general attitude on the stand, the court...
And the fact that the video didn't support what he was saying, or at least you couldn't see the same things. And I know the argument always is you can't...
Right.
The video
the angles and whatnot.
distorts the
exactly.
Vision. But, so I'm back to my question of if there were, how do we get, what is your best argument that we can even move past the no reasonable basis to stop, assuming that we can't evaluate the credibility of the witnesses, and given the fact that, assuming the fact that there was no basis to stop this car, how do we get to a valid request to take a breath test?
Because I don't believe that ends the question, whether or not it stops the vehicle. Now that we're kind of discussing it, I do think that the officer has to consider, or the court should consider the whole encounter, not just the stopping of the vehicle. And the subsection that you read includes whether or not there's a proper arrest as well. And after the officer stopped this particular appellee, the court found that there would have been proper reason to arrest him. So I think the question is more encompassing than just stopping the inquiry at whether or not he had reasonable suspicion to stop the vehicle in the first place.
Counsel, using your argument, it would seem that police officers can stop anyone they would like to, and if they find something, even if there is no reasonable suspicion, no probable cause, if they find something, then it's okay. And I don't think that's what either the statute here or the Fourth Amendment jurisprudence says. We don't want them to do those things, even though they might find something of a criminal nature or a civil nature that would allow them to withdraw the driving privileges.
And I would agree with that statement only in the criminal context. I would agree with that statement in the criminal context, but this is a civil proceeding. The implied consent statutes make room for that with the subsection that deals with the remedial nature of those statutes. Martin versus Kansas Department of Revenue is a very big case in our world, and it dealt with that exact same question, whether or not the exclusionary rule, if you should exclude evidence that the court has found to be illegally obtained, that exclusionary rule does not apply in administrative proceedings.
Let me interrupt you with some questions here.
Yes.
A line of questioning.
Oh, great.
And ultimately, the fundamental question is, why are we even talking about the exclusionary rule, or why do we need to talk about it? I'd like to focus, since Martin, you were talking about Martin.
Yes.
And since Martin, the legislature amended 8-1020 subsection P.
Yes.
Right? And that's mainly what this case is about, correct?
That is correct.
Do you have the language of that amendment in front of you?
I can get it. Yes, Your Honor.
Now, the new amendment says that basically in an administrative proceeding, like a driver's license suspension case, when it gets to district court, now the court can consider and determine the lawfulness of the law enforcement encounter. That would be the basis for the stop, right?
That is correct.
That part of the statute at least abrogates Martin, correct? Because in Martin, the court said a party can raise constitutional issues, but the district court can't decide them because that wasn't one of the grounds for a court to consider back when Martin was decided, right?
That wasn't a grounds for consideration, yes.
But now the statute clearly says the court can consider and determine the lawfulness of the law enforcement encounter, i.e. the basis for the stop. Is that correct?
That is what the subsection says.
And then the subsection goes on to say that if the court finds the grounds for the action by the agency have been met, the court shall affirm the driver's license suspension, correct?
Yes.
Now, can't we at least glean from those words that if the court finds that the grounds for the agency action have not been met, the court won't affirm the driver's license suspension? Is that at least a fair reading?
That is a fair reading. However, I would argue in a position of Kansas Department of Revenue and even another panel of this court that that is not what the subsection, the subsection didn't put that in the reading, and we're basically reading too far into it to say that the legislature intended for the court to be able to dismiss administrative suspensions based on the stop.
Well, the Judge Vano, he kept saying there must be some reason for this amendment. Why do you allow a judge to determine now if the stop was good, if the judge can't do anything based upon his findings, correct? That's kind of where our judge was coming from, right?
That is what he said in his opinion.
Why isn't the language of the last sentence, though? It tells the judge, I'll affirm the agency action if the grounds for the agency action have been met, right? It expressly says that. Can't we at least glean from that if the agency action hasn't been met, he won't affirm the administrative suspension?
I think that line actually proves our argument in that the legislature obviously intended how to put very declarative language in the subsection, and it chose not to. And so, or maybe by mistake, it didn't include that. But as Wiggum versus Kansas Department of Revenue held, the legislature didn't go far enough to change the statute.
We don't need to follow Wiggum, of course. And
No.
it's on a petition. Petition for review has been granted,
That is correct.
which kind of tells me something.
We often say they don't take petitions for review to give us an attaboy.
Right. Believe me, I worked for the appellate defender office for years. I completely understand where you're coming from.
All
on
right,
that.
but I'm being argumentative here, but if I'm right that this new amendment is clear enough, that if the court finds that the grounds for the agency action have not been met, the judge shall not affirm the suspension. If that's a fair reading of this new amendment, do we even need to talk about the exclusionary rule? Because I sort of agree with you, the exclusionary rule applies to criminal cases, not administrative actions. But do we even need to be talking about it? To me, the answer is in the language of the amendment. It tells the district judge whether it tells the district judge that you can now consider and determine the lawfulness of the law enforcement encounter, i.e., was the stop valid? And there's got to be some reason to make that determination, and that is, if you find that the stop was bad, you don't uphold the driver's license suspension. And forget the exclusionary rule. The judge is just following the language of the statute. Why am I wrong in saying all that?
I don't necessarily think that the court's statements here are incorrect, but as an advocate for Kansas Department of Revenue, I have to argue the opposite side, that the court in Wiggum was correct in that the language doesn't go far enough. And Justice Beyer, in a very famous line for at least defense counsel, said that it is not the court's role to darn the socks of the legislature. It isn't if the court or if the legislature incorrectly did not put language that goes far enough to change the law as it currently stands, it's not the court's responsibility necessarily to fix it for them.
I know we're way over your
Yes.
time here, but I had a question I wanted to ask too, because you have not been on the hot seat long enough. Neither you nor counsel for Mr. Jarvis mentioned the Sloop case. And I'm wondering why Sloop wouldn't be applicable here. In Sloop, the Supreme Court said an arrest must be lawful before an arresting officer is authorized to request a test. And this was a 2012 Kansas Supreme Court case. So, and in that case, they found there wasn't a basis for the stop, even though they had a valid traffic no tag light, and nobody disputed the truthfulness of that fact. But they found if there was no basis, an arrest must be lawful before an officer is authorized to request a test. So why is Sloop not applicable here?
I would agree that it probably is applicable, except if I remember correctly, the facts of Sloop were that he had a valid reason to stop the vehicle,
Right.
but then after that, there wasn't necessarily enough evidence to support
DUI, right.
DUI. Here, we kind of have the opposite problem, except that, of course, we would argue he did have reason to stop the vehicle, and then the evidence after that, even the district court agreed there was sufficient evidence for probable cause. So I think it would apply to this case, except that the facts of this case still support a proper arrest.
So you're focusing on the arrest for the DUI, not the stop.
I think the stop, the testimony of the officer supports a lawful stop as well.
Okay, thank you. We'll still give you a couple minutes in rebuttal.
Good morning. May it please the court, Sheena Foy for Appellee Nathan Jarvis. This is my first appearance in front of the Court of Appeals, so I thank you for having me. Kind of already covered a lot of the issues. I think the court's laid it out pretty clearly that the issue of reasonable suspicion was addressed pretty succinctly and forcefully by the district court in this case, and so then we're left to whether or not there can be a license suspension following an unlawful stop. And it is our position that no, there cannot be, based on the new amendment, not new, but the 2016 amendment to the statute.
Counsel, are you familiar with the Sloop case? We noted, as Judge Arnoldberger pointed out, that neither one of you cited it in your briefs.
I am familiar with it, and as soon as you mentioned it, I recognized that I should have cited it. Counsel before me is correct that our facts are a little bit different in that, I was trying to narrow in just on the reason for the stop itself versus getting into whether there was a basis for a lawful arrest. But yes, I wish that I had included that case in my briefing.
Do you think it's applicable to this case? The Sloop decision?
Yes, I do.
Well, how is it applicable when our judge said that there wasn't a good stop here, but the judge went on to find that if you get past that, there was reasonable grounds to request the breath test here, meaning the probable cause for a DUI.
Correct. So we had raised several issues at the district court level that we did not appeal those particular findings.
Correct.
And so I think in his decision, he was addressing everything that we had raised at the district court level. But just because there was then later facts that the officer observed that led for probable cause to arrest for DUI, that does not, he doesn't then get to bootstrap back to include those facts as the reason for his stop. I would disagree with counsel before me that there was testimony that would support the fact that there was facts prior to the video starting that the officer observed that would have been the basis for the stop. I think the testimony of the officer in the record was that the violations occurred on an unlaned portion of the road, and the video begins on a laned portion of the road. So I would just like to correct that. I think when you're looking at the statute language, the legislature is enacting laws to have a purpose. The presumption is that the legislature does not enact meaningless legislation. If you are to follow the Department of Revenue's position, essentially petitioners would be raising these issues for the court to tell them either yes or no, there was a violation of some constitutional right. However, I have no remedy for you. And that would render this legislation meaningless. And so we do not believe that that is the intent of the statute, nor do I think you even need to get to that point, because I think on the plain language of the statute, it is clear that they intended these issues to be raised, not for some superfluous purpose, but so that petitioners could have a remedy. In the Martin case, there's discussion about the balancing test that was done, and that this was done to address public safety concerns. I don't believe that allowing constitutional issues to be raised at a trial court level on these type of hearings creates any public safety issue. An officer still is able to pull over a vehicle that it observes to be impaired either by committing an actual traffic infraction or some other reasonable suspicion that they can articulate. What this is stopping is baseless searches and baseless stops. We are not putting any additional burden on law enforcement. It is the same standard that they have to apply in the criminal context. There's not going to be an additional burden put upon them. And I also don't think that this is a situation where if you find the statute allows for the court to issue these remedies, that there'll be a floodgate. The burden is still on the petitioner. It has to go through the administrative proceeding. It has to appeal to the district court level. And then the court still has to find that there was no reasonable suspicion for the stop. And so I think the legislature recognized that this was an issue. It took the appropriate steps. This is not a judicial created remedy. This is something that the legislature took. Martin had been in effect for 8 years, and our position would be that the district court was correct in finding that there was no reasonable suspicion and correct in overturning the administrative license suspension.
The legislative history is full of references to the Martin decision, correct?
Correct.
Which would sort of indicate to the court or anyone reading the amendment that the purpose of the amendment was to essentially abrogate Martin. Is that a fair statement?
Yes, that's my position. And if there are no further questions, this was sort of a narrow issue. I would waive the rest of my time.
Thank you. You're never penalized for
Okay,
giving up some of
thank
your
you.
time. Thank you very much, and welcome to your first argument.
Based on opposing counsel's argument, I don't have anything further to add, and I'd waive my rebuttal time unless the court has further questions.
Thank you very much, counsel. Thank you both. We'll take this matter under advisement and get to a decision as soon as possible. Last case is State versus Weaver. The parties will state their appearances.
Good morning, Your Honor. May it please the court, Jacob Gonteski on behalf of the plaintiff, the appellant, the state of Kansas.
Okay.
Good morning, Your Honor. Mr. Weaver appears to counsel Adam Stolten.
Okay, thank you. And did you wish any rebuttal time?
If I could reserve 3 minutes.
Okay, you got
Thank
it.
you.
Whenever you're ready.
Thank you. One Friday afternoon, James Trent was driving home at 175th and 169 highway here in Johnson County, Kansas. It's a busy highway speed intersection with a traffic light. Excuse me. James Trent was stopped at the red light, several cars back in traffic, when the light then turned green, but traffic ahead of him failed to move. When it failed to move, the traffic ahead of him started going around another vehicle that remained stopped in his lane of travel. When James Trent started going around that vehicle, he looked over and he realized the driver of that vehicle was slumped over the steering wheel and appeared unconscious. So James Trent pulled over to the side of the road and approached that vehicle. He got out of his own and walked over to the driver's side of what turned out to be Ralph Weaver's vehicle. And he started rapping on the window, trying to arouse Mr. Weaver. Unsuccessfully, he smacked on the door and he called 911, and he was unable to wake Mr. Weaver. He got 911 on the line, told them of what was going on. He began reaching through the window, hoping that perhaps he could unlock the door. He realized Ralph Weaver's vehicle was in drive while Mr. Weaver was behind the wheel, apparently unconscious. He tried to reach through the window to unlock the door and then startled Mr. Weaver, and Mr. Weaver finally woke up before officers arrived. And when he woke up, he said, "I got to get out of here." And he began leaving. And Mr. Trent said, no, you should stay. Somebody should check you out. Somebody should see what's going on. Mr. Trent stuck around. Mr. Weaver started to pull away just as officers arrived. And when Deputy Purdon arrived, he found Mr. Weaver's vehicle turning through the intersection, and Deputy Purdon immediately stopped Mr. Weaver. They pulled to the side of the road, and Deputy Purdon approached Ralph Weaver and said, "What's going on, man?" And Ralph Weaver was a little out of sorts and said, "Oh, I don't know. And he said, "Well, I just got a call that you were passed out behind the wheel. You were slumped over the wheel. Is something going on?" And Ralph Weaver said, "Well, maybe I must have just fallen asleep for a minute." And the officer said, you can't be falling asleep behind the wheel on an intersection like this on a Friday afternoon at 3 o'clock. And Ralph Weaver said, "Oh, I realize that, man. I realize that, but I'm fine." And Deputy Purdon, as he noted when he testified, he did say at the outset, "Have you been drinking? What's going on here?" And he said, no, I haven't been drinking. I was on my way to go to the Missouri side to buy some cigarettes where they're cheaper, but I haven't been drinking. And the officer then said, "Well, do you have some medical issues? Is this a medical episode going on?" And he said, "Well, I do have a lot of medical issues. I'm on a lot of prescription medication." Deputy Purdon noted that MedAct Medical was en route to check him out. And the deputy said, I don't know what's going on here. Did your blood pressure drop out, or what's going on?" And he said, "I don't know. It could be. I'm on blood pressure medication." So medical was on their way, and Deputy Purdon already knew something was amiss here. Deputy Purdon had a reason to stop Ralph Weaver that day. The initial stop was not questioned.
Interrupt you. I wanted you to lay the facts of the case, but
Yes.
now the judge suppressed the evidence, which is why the state's appealing this case.
Correct.
And in the Appellee's brief, they say that our court has no jurisdiction to hear this case.
Right.
Because your notice of appeal was untimely.
Right.
And you didn't file a reply brief to respond to any of that. Before you get into the merits of the issues here, please address the jurisdiction issue.
I'm happy to. If we go through the timeline on the jurisdiction issue, the hearing was held on the motion to suppress on July 12th.
Yes.
At the conclusion of that hearing, the judge he noted he was suppressing the evidence. He did not issue a written order, nor did he indicate from the bench whether he was going to or not.
But he clearly granted the motion to suppress.
Unquestionably. He
right.
granted the motion to suppress and was silent on whether he would issue a written order.
Correct.
The state noted at the conclusion of the hearing that it would like to reserve the opportunity to potentially appeal or file a motion for reconsideration, asking the district.
Does that matter to anything?
I believe it does. I believe it does, to the extent that the district court never indicated it was not open to such a request. The district court never said, I'm not going to reconsider this. This is a final order. I'm issuing it today. That's it. The district court never said as much.
Maybe the judge expected some sort of timely motion to reconsider.
Well, when the judge, and the motion was timely to the extent that the judge set the case out and said, let's set it out, and we will come back. If you have filed something when we come back, we'll take it up.
Did the judge actually say that?
He did not, but by setting it out to another date, that was affording the state to make their filing. And they set the case out to August 1st by agreement of everybody in the room. And when the case was set to August 1st, before the parties convened August 1st, then the state filed its motion for reconsideration. And then the parties convened in court on August 1st.
So I'm a little foggy on the facts. They set the August 1st date right there at that first hearing?
At the end of the motion to suppress hearing, it's at the end of the transcript, they set the August 1st date. And the state's line, and I believe I quoted the state, but the state said we would like to reserve the opportunity to potentially appeal and potentially file a motion for reconsideration. The state then deferred to defense counsel on how to set the case. The court offered a scheduling conference of August 1st, and defense agreed to that. And then it was after that date the state filed the motion for reconsideration, and then the parties convened on August 1st. Because the state...
Didn't defense counsel say at that hearing that he had an issue with the court's jurisdiction?
He did. When they got back on August 22nd to take up the state's motion for reconsideration, defense counsel did argue that the state was out of time.
Judge didn't make any ruling on it, though, right?
Well, he didn't explicitly talk about the timeliness of the motion, but he did say he had jurisdiction to consider the motion for reconsideration. So he did rule on defense arguments' claim that the motion shouldn't even be heard. And the judge did say at that time, I believe the motion is properly here before me. I will entertain it. And then the judge revisited some of the arguments the state had made in the motion for reconsideration and talked about some of them. The judge rejected other arguments that the state had offered in the motion for reconsideration, saying, those are new arguments you never made before, I'm not going to take those up.
Does your whole argument hinge on the fact that they set the August hearing date in that first hearing?
It hinges on that and the fact that the judge did not issue a written order and was silent on whether he would or not.
Well, if the judge didn't issue a written order, the only thing we have is the July 12th ruling where the judge clearly denied the motion to suppress.
The judge did later issue a written order. After the August 22nd motion for reconsideration, a written order was filed memorializing what had taken place.
In your brief, on page 10 of your brief, you say just the opposite. You say that no written order was ever filed in this case.
It wasn't, but it was later, and it's part of the appellate record. It was filed on September 11th of 2018. It's volume 1, page 11.
When the appellee filed a brief clearly challenging our court's jurisdiction, and you don't even reply to that, why shouldn't we just say you lose?
You shouldn't say I lose, because when you look at the case law on this sequence of events, the case law shows that jurisdiction still holds.
How do we know that case law if you didn't tell us what it was? I mean, you didn't argue any of that case law.
It's true. I'm here to argue it today, but I did not put it in a reply.
Okay, so what case law supports your position?
The case law that supports the position is State v. Campus, 2014 Westlaw 408-2408, states that when no written order issues immediately but does later, that date controls for the purposes of a notice of appeal of that order.
What did you say? That it was state versus what?
State versus Campus, C-A-M-P-A-S.
Thank you.
2014.
I got the sign. I
Okay.
just-
I didn't
But-
get
Oh,
to
sorry.
finish out the
Okay.
site again.
2014 Westlaw 4082408.
And so you didn't feel compelled to give us a reply brief to cite this case that you're now telling, an unpublished case that you're telling us is on point?
I wish I had.
Yeah, would have been a good idea.
It would have. I could revisit, I could pull my calendar up before me from when these briefs were being filed, but it's something I should have taken my time to do, clearly.
Counsel, should we say you've abandoned that issue because you haven't briefed it, even when specifically challenged on that issue?
I have not waived the issue of jurisdiction.
Well,
when-
if you don't respond to it, don't we usually say, and that's usually because the defendant has been making the argument, don't we usually say that if you don't argue it, if you don't brief it, you are presumed to have abandoned it?
If I don't brief it at all, yes, but I believe I sufficiently briefed jurisdiction and preservation in my original brief when I laid out the sequence of events. And
Those
actually, the motion
Are
for...
those the same, preservation and jurisdiction? Are you saying they're the same thing?
I overlap them, absolutely.
But they're
It-
not really.
To the extent that timely preservation by the state is required to vest this court with jurisdiction, they are the same to that extent. I'd also point out, if the state's motion was untimely, then presumably the district court judge was erroneous for even entertaining the motion for reconsideration. He made it clear when he set the date out that he would entertain that motion. When the motion was filed and it got set for a hearing date on August 22nd, he actually entertained that motion. 2 years ago, in State v. Evans, this court, this panel, sitting at this school 2 years ago this month, took up State v. Evans and clearly stated that a district court has jurisdiction to entertain a motion to reconsider. It can entertain that motion to reconsider at any time it's raised. It can even entertain that motion for reconsideration at trial. This panel stated clearly the justifications for that, which are absolutely reasonable.
So what's the side of your Evans case?
Excuse me?
Evans. Do you have a
Evans?
side on that? I presume it's not in the brief you didn't file.
While I'm looking for it, I will point out that in State v. Evans, the issue was raised, and the reason why this panel said that the district court has jurisdiction to continue entertaining such is because if the district court can entertain that idea in the middle of trial as the case proceeds, then the district court should equally be able to entertain it before trial at any time that it's raised. I thought I had Evans before me. I don't have it in the page that I have here. It's a 2017 case from this court. Jurisdiction was
Why don't, in the very little time you have left, why don't you briefly address them? Let me ask you one question on the merits.
Please.
What bothers me about this case is that your officer was conducting a DUI investigation at the same time they were checking on the health of this driver. Two things were going, you kind of had a public safety stop and a DUI investigation going on at the same time.
If you watch the video, which I hope this court has had an opportunity to do or will do, from the outset, Deputy Purdon did ask initially whether or not Mr. Weaver had been drinking. But after that, Deputy Purdon's focus was clearly on the medical issues. He asked him about medication. He talked about his blood pressure.
Yeah,
Deputy
but
Purdon is
He was
trained.
doing alphabet tests and things like that.
That came after MedAct had arrived and evaluated Mr. Weaver behind the wheel, and Mr. Weaver said he was resisting any further medical treatment. Medical was being cleared before the alphabet test was ever administered. That's the time that it broke. That's the time that the EMTs were clearing the scene. They were telling the officers, he doesn't want to be transported, he doesn't want anything further from us, we're going to leave. And the deputies immediately then asked him the alphabet test. The only extent of a DUI investigation that occurred before that was that as the deputies were waiting for MedAct and talking to him about medical issues and medication, they made observations that they didn't detect an odor from him, that they asked him if he had been drinking, and he said no. And one officer did tell the other one, I do see his eyes shaking, which is a sign of intoxication. And so the officers were not engaged in a DUI investigation at the time the priority was placed on the medical issue. When medical began to clear the scene, that's when officers then went into gear on a DUI investigation. To say that they were erroneous to do so would require these officers to turn a blind eye to clear evidence of intoxication. Mr. Weaver was clearly intoxicated that day. And to tell deputies that because they had asked Mr. Weaver if he had been drinking when they encountered him when he was passed out behind the wheel, that tainted the investigation would present a horrible incentive for officers to start ignoring these types of facts on this type of call.
If there are no other questions, I think you're out of time. I'll give you a minute in rebuttal, but
Thank
you've
you.
used all your time.
Good morning. Adam Stolte appearing for Mr. Weaver. I'll just go through my brief in order unless the court has any other questions I'd like to jump ahead to. I think my sub-issue 1, that this court lacks jurisdiction, controls this matter. Was not able to pull up Evans or Campus as Mr. Gonteski was speaking. But the facts I gleaned from Campus was that you jump back to the date of, and I think that would jump us back to the date of the motion for reconsideration, not for the motion to suppress hearing, in which case 3603 controls, the 14 days have passed, and this court lacks jurisdiction to hear this case at all. At the close of the motion to suppress hearing, it seemed clear to me that the state, the prosecutor, was going to go back, talk to the other prosecutors, make a plan. I think it would be at that point that that plan would have to include 3603 and the 14-day time limit, or to move forward without that, or move forward on the case without that evidence. I think 3603 controls. I think there's no jurisdiction. To the extent that this court finds that there is jurisdiction, I would say that the state here has not sufficiently briefed the issue of why the court erred by failing to grant their motion to reconsider. Motion to consider hearings are limited to just a couple of things: whether or not the district court misapprehended the facts of the case, misapprehended the party's position, or misapprehended some kind of controlling law. The court in this case actually stated it's not an opportunity to make a backup argument, which is what I believe that they were doing here. Moving on to sub-issue 3, Gonzalez is a really interesting case. Thinking about Terry v. Ohio and the actions of officers in this case, Gonzalez really does two things for the citizens of Kansas. One, without Gonzalez, cases like this could happen here, where the officers are actually interfering with, in my opinion, the investigation. They had him doing finger tests. They had Mr. Weaver doing ABCs while the investigation or the medical exam was going on. Wasn't really clear to me whether or not who was in front here, whether or not the officer was in front of this investigation, or whether or not the EMTs were in charge of this medical exam. But it does seem clear that they were interrupting the exam, and I think that that's what Gonzalez is. One of the things that Gonzalez is here to do is to stop that from happening. The other thing that Gonzalez says is that this is how we protect ourselves under the Fourth Amendment from pretextual public safety stops. There's means to protect ourselves from pretextual stops in other instances of Fourth Amendment law, but Gonzalez is here to do that for the citizens of Kansas.
Excuse me, counsel,
Sir.
but looking at the facts of this case, I can't see that the officer was doing anything wrong. This person was seen slumped over the steering wheel in a busy traffic situation. And I would be puzzled to have somebody, show me that that was not the right thing to do.
I just have one follow-up question. Which officer, Judge? There was two officers. There's Neal and Purdon. Neal was the first to arrive, and Purdon arrived.
I think it was Purdon.
Purdon?
I'm trying to remember which one was which.
Well, I'll just pop down my list here. So my problem with Neal, who's the first one to arrive, the first thing that he did is he took his license and said, you can't go anywhere. He seized under the Fourth Amendment. That is not a public safety stop. That's outside the grounds that we allow for public safety stops. His immediate questions was, have you been drinking? He said he didn't smell alcohol. No one ever smelled alcohol during this whole thing. And he asked if he knew where he was. Mr. Weaver said that he knew exactly where he was, cited the exact intersection. And Neal actually stated on the record.
Even a public safety stop, just trying to get kind of the lay of the land. Have you been drinking? Do you know where you are? I mean, those seem to be reasonable questions related to the safety of this individual, because the most likely, or one of the more likely things that could happen here when somebody falls asleep at the wheel is they've been drinking.
That's one of the
He
things.
said, I'm tired. Okay,
Sorry, Judge.
go, yeah.
That's one of the options, and that's what Gonzalez does, Judge.
Right.
It makes sure that that is the option.
I mean, I agree with the point about taking the driver's license, but just asking the question, have you been drinking? Do you know where you are? Is consistent with a public safety stop, don't you think?
I agree, Judge. I used to be an EMT.
Yeah.
I mean, I've dealt with this.
Right.
But, we didn't take people's licenses.
Right.
And then the problem that I have, going back to you, Judge, the problem that I have with Purdon here, and I think that's what the district court focused on, is his actions. He interrupted the EMTs for 5 to 7 minutes. That's what the district court judge said. He was in the car doing DUI testing while the EMTs were still on scene before they cleared him. We don't know if what the EMTs were doing at that time, but it's very clear that Purdon took over this investigation. It's very clear that Purdon, I believe, first of all, that Neal did violate Gonzalez. I also strongly believe that Purdon definitely violated Gonzalez here. And again, he also did not smell alcohol, and I understand she needed DUI just on prescriptions. But at that point, what the district court judge said is there's no evidence of a DUI at this point, but they're beginning their investigation anyway. Unless there's no other questions, I'm willing to waive the remainder of my time as well.
Other questions? No? Thank you very much, counsel.
Thank you, Judge.
I'll give you a minute.
Well, let me just interrupt you with some
Well, you may
questions.
have more than a minute.
As it turns out, I've got the transcript of this July 12th hearing, and after the judge granted the motion to suppress, the district attorney said that he wanted, Judge, for the record, I would like to reserve an opportunity for a potential appeal and also for a potential motion to reconsider.
Right?
And then the prosecutor said, I would like to take an opportunity to discuss this case with the other attorneys in my office to figure out how we're going to proceed.
She's a young new attorney, correct?
And then the court indicated it could be set on a scheduling docket.
Correct. To see if the state would file anything. If the state didn't file anything, this case would presumably be dismissed. If the state did file something at that scheduling docket, they would figure out a time when everybody could convene to hear the motion.
But it wasn't, that's a little bit different than scheduling the motion to reconsider on August 1st. The court just said the next scheduling docket happens to be August 1st. If you file something, we'll take it up then.
Right. The court, I never argued the court was going to take up the motion on August 1st, only that we would set it out for a scheduling conference to see if the state was filing anything.
All right, thanks.
State v. Evans is case number 116022. As I said, it was this same panel of this court convened here, but across campus in the other building. 2017 Westlaw 544565. Gonzalez is the case that Mr. Weaver hinges his entire argument on, essentially. But the quote here in Gonzalez at page 455 Once the officer has completed the inquiry necessary to satisfy the purpose of the initial detention, the public safety stop here, the interaction about EMTs and all of that, when medical was cleared and Mr. Weaver said he was done with them, he or she, the officer, must allow the person to proceed unless the officer has a reasonable suspicion of criminal conduct. By the time in this stop, Mr. Weaver said he had visited with the medical officers that you can see in the video, and he said, I don't want to be transported, I don't want to go, I'm done with medical. By the time he had told that to medical was the priority of the call, you can see it in the video. By the time he told that to officers absolutely had reasonable suspicion to proceed
What's
with
the
a DUI.
impact of them taking his driver's license from the get-go?
A public safety stop is a detention. It is a seizure. Officers can seize somebody for a public safety stop, and until the public safety stop is resolved, he can be seized. They could have boxed him in with their cars. They could have taken him out. The impact of holding the license is of no consequence here because the initial stop was never challenged here. The initial public safety stop is not what's at issue. In this case, it was never challenged at the district court. He never argued that by holding his license at the outset that was problematic. It wasn't then, it isn't now, because officers had justification to pursue that public safety stop. By the time the public safety stop ended, they had reasonable suspicion to proceed to DUI. To say officers at the conclusion of that medical episode had to clear the scene or risk tainting this public safety stop is just an absurd outlook on how officers do their jobs. To require them to say, Mr. Weaver, since you won't talk to EMTs, I know you were passed out behind the wheel at this intersection, but I've got to let you go. That can't be the case.
Questions from the panel? Okay, thank you very much. We'll
Thank
take
you.
this matter under advisement and issue opinion as quickly as possible. All right, with that, that concludes, and counsel, you're more than welcome to stay in case there are questions from the audience to counsel in general. But we are willing to answer any questions any of you may have about the Court of Appeals, how we operate. We just cannot answer any questions about these particular cases. And I notice we have several of the attorneys still here, and we have another attorney in the audience that I'm sure would be willing to answer questions too. So with that, do we have any questions? Now's your chance. Yes, ma'am.
Can you explain a little bit further to everyone what your job as the judge, how that's different at the trial level versus the appellate level?
Want to take that? Since you had both?
Well, I'll try to take a stab at it. At the trial level, I don't think you would have had judges grilling the attorneys the way we do here. At the trial level, the judge just needs to let the evidence come in, especially if there's a jury who's going to be the fact finder, and the court doesn't typically interject itself and question the attorneys the way we did today. Once it goes on appeal, though, then it's just a matter of having legal issues before the court. We're trying to figure out if there was any error below. And so when you get to an oral argument like we get today, it's typically filled with judges asking various questions. Maybe we don't even sometimes let the attorneys get their argument out, but we have very specific questions about the case, and we want to ask them and get answers for them, and so that's why the hearings proceed the way they do.
And as a follow-up, then, how does the appellate court decide which cases to hear as oral argument?
We don't have this court doesn't have, which cases to decide an oral argument or which
ones to hear oral arguments?
Okay, well, first let me say that we don't have any choice in which cases come to us, because if you have a hearing in district court or before an administrative agency or anything, you have a right to appeal to our court. So as an intermediate appellate court, we take all the cases that come to us. If they are dissatisfied, if the parties are dissatisfied with the decision from our court, then they file a petition for review, which we mentioned earlier, a petition for review with the Kansas Supreme Court. And then they can decide to take the case or not take the case. And of the 1,600 cases, opinions we issue a year, they end up taking from us about 110 maybe, where they'll accept petitions. They will grant the petition for review to consider the case. As far as how do we decide what cases are to be orally argued, when the parties file their brief, they have an opportunity to request oral argument. So that would be the first thing we would look at. Did the parties request oral argument? If they did not request oral argument, we may still look at the issues and determine whether or not we think those are significant enough issues that we will have lots of questions on and want to answer. If we do not select the case for oral argument, but the parties really believe it should be orally argued, they can make a motion to us after we've set it and say we really want oral argument on this case. Or if we as a panel get the case and start to look at it and say, you know, we really think that oral argument would be beneficial here, then we can set the case at that point for oral argument. So there are lots of stages along the way, and we try to give the parties a say in whether they want it or not.
Many of the cases that we hear are criminal appeals, many of them having been filed by the defendant, him or herself. And often they would be tickled pink to be able to get out of prison for the day and come over to Topeka and argue the case. We're usually not going to grant that unless there is some significant reason why we want to hear that case. Because we know, prisoners want to get out for a day.
Yes, ma'am, right here.
When you say you hear the oral arguments, if you're not listening to oral, are you just reading the brief? You're just making your decision based on?
Yeah, probably only about 25% of the cases that come before our court actually get orally argued. The rest of them, 75%, we're just getting in the briefs, reading them, discussing among ourselves, and issuing a decision from the briefs and the transcripts. And as you can tell from this oral argument, we are very familiar with the case by the time they get here for oral argument. We've read the briefs. In many cases, we've delved into the transcript of the trial. We may have read the entire transcript of the trial. And so we know, and we don't generally discuss the case, the three of us, before we come for oral argument. But individually, after reading everything, we kind of know what questions have come up to us that we want to, like why did you look at this case, or what's your best response to this? Because that's what is what is going to help us decide. So although I know attorneys, it's very nerve-wracking to stand there and not know what questions are going to be asked and be prepared to answer, but really the best thing that could happen is that we ask a lot of questions, because that gives them a clue as to what is going to be important to us, and they can focus their short 15 minutes on that.
What, did we have about 20 cases this docket, and we had oral arguments on 3?
Yeah, so when we finish here, we will sit down, the three of us as a group, and decide all 20 cases. So we'll see how that goes. Okay.
Well, you just went right into my question. Can you please explain how you go about, as a panel, rendering the decisions in cases?
Do you want to take that, Joe, or you want me to?
All right. Well, as you note, there are 3 of us, and there's a reason for that, and that is if you have 3 judges discussing the case, you're probably going to get a more full explication of what the positions are on each side. And so prior to deciding these cases, we have the opportunity to read over the briefs, to read memorandum that are prepared by research attorneys, and we therefore even if we don't have oral arguments, we have quite a bit of information that has been given to us on what is the appropriate disposition on this case. And so most of the time we will sit down and we'll say, well, what do you think? And it will go around and we'll discuss it for a while. It may not take long if it's a simple case. It may take a lot longer if it's a more complex case. And so mainly it's talking among ourselves. And then after we decide it and an opinion is read, it's available to our colleagues on the court to look at our decision and decide whether maybe they want to add their arguments to it. Now, the answer comes from the three of us, but we listen very carefully to those things that are said by our colleagues, because oftentimes they come up with very good things that perhaps we didn't realize were there.
And it may be, for example, this afternoon when we sit down with these 20 cases, that, we'll go around, each will state our opinion as to what we think on the case. We'll trade information, that's really one of the wonderful things about an appellate court versus being the sole decider in district court. With three people, you really have people bring up things that you didn't think about before, and you may read it and think, oh, I understand this should be like X, and then your colleague will say, well, yeah, but what about this? And it's something you never thought about before. So it's really a very dynamic process. Now, it may be, as we discuss the cases today, there may be some cases that we feel, well, we really don't feel like we have enough information on that case. So we may talk to our research attorneys about going back and getting more information, or one of the judges may say, I kind of agree with you, but before I decide how I want this case to come out, I need to go back and do some more information. And so then we'll reconference the case later. It could be that the case gets written up and somebody changes their mind. It's all, until that case is out and published, it's a very dynamic process. I've had cases before where you write, the practice in our court is, if the decision is 2-1, the one has to write a dissent. You don't just get to say, I dissent, you have to state the reasons for the dissent. There have been cases where we've gone through this whole process, the dissent presents their case for the other two to consider, and the other two say, I think you're right, I'm changing my mind. And so it flips so that the dissent becomes the majority opinion. So all of this is going on all the time. And it's very, very interesting. And I think we try very, very hard to come to the right decision. And we try very hard to come to a unanimous decision. So, I think you would find our court compared to many other courts around the country. We do have dissents and we do have concurrences that are filed, but it's fairly rare. They're usually unanimous decisions, and that may mean we limit the case a little bit from what maybe one or the other wanted to do, because we can all agree on X, even though we may not agree on Z, Y, and but we can come together on an opinion that we can all agree on. Yes, ma'am. No, there aren't any dumb questions.
So, as you had said before, you get all the information ahead of time before the oral argument. Is it possible that you all come to a like decision ahead of time, listen to the oral arguments, and if there's no changes in you all being, unanimous in the decision, are you allowed to make a decision right then and there?
Orally at the, we could say,
During this whole process, after you guys are, the case, arguments, are you?
you've been on here longer than me.
Like I said,
We've never done it that I've known.
Theoretically, it's possible, but no, we wouldn't do that, because the last stage, the actual writing of the opinion, can bring changes. I heard one Southern judge say, every once in a while, we find a case where that dog just don't hunt, And when you're writing the opinion, you may all of a sudden discover, well, wait a minute, this was very clear to me during oral argument or during conference, but now that I have to sit down and write in great detail why we are doing what we are doing, I see some problems with it. So we may well change our minds, and that happens. But we're not going to do that right at the time of oral arguments, because then you miss another opportunity to look at the case and maybe come up with some additional issues that should be addressed.
And you know, when we disagree, it's very collegial. I mean, it's never like, oh, Joe, you're such an idiot. I mean, it's never like that at all. It's always, and often a
Why am I always the one who's the idiot? I just
it's always, you know, there are times when the majority may say, I think you should write a dissent. I think this position needs to be put out there so that when the Supreme Court is looking at a petition for review, they can see both sides laid out on this panel. So, you know, we don't get angry when somebody writes a dissent or a concurrence. It's usually adds to the issue in some way, shape, or form. Mm-hmm.
I have a question, hopefully I can get it quick. But anyway, I noticed, I'm not talking about the case, but I noticed that when you come to the panel in your discussion, like versus Martin versus this and whatnot, so do you have a research person that pulls those for you, or do you just know them all?
Oh, we know every case off the top of our head. Well, there are some cases that in certain areas of law are just well-known. So the Martin case, for example, is a well-known case. But the parties in their briefs will have alerted us to certain cases. So that tells us that what cases we should be reading ahead of time and looking on. And then our research attorneys will also find cases that they think we should look at. And we have one of our research attorneys here. Callie is a research attorney for Judge Malone. And so she helps pull everything together. When the case first comes in, the research attorney gets the whole file and tries to kind of summarize the facts for us and outline the parties' arguments. And so very, very helpful work. And they work very closely with the judge they work for.
Also, Callie is a former student here, so.
She's amazing.
Have somebody like that.
Yeah, otherwise, you know, we're a high-volume court. So, you know, we may have 20 cases this docket. There have been dockets when we've had 30 cases, and you have one oral argument a month, so you've got to read those cases, be prepared on those cases, write those cases, and then be ready the next month for the next group of 30. So it's high volume. We can use all the help we can get. Yes, ma'am.
Does an attorney's delivery have much impact on the outcome?
Their delivery,
Or, you know, help with presentation and, you know, to what degree do you base it just on their brief or their,
well, I think I'll give each of us a chance to answer that. I mean, kind of the question is, does oral argument kind of help, can it help or hurt your case? Or I don't know that oral argument can hurt your case, but there have been times when an attorney is really just has hit on the issue so well in a way I never thought about it before, that it certainly changed my position or made me think about something I never thought about before. So it can be very important. Joe, do you?
Well, I pretty much follow that. Many people say, well, does oral argument do any good? And I said, yeah, you know, maybe in 5 to 10% of the cases it may impact on the decision, not necessarily the result, but perhaps the reasons for the result. And there have been times when I have gone into the courtroom to hear arguments totally convinced that one side was correct. But during the oral arguments, during their arguments and our questions, I said, well, wait a minute, I think I'm wrong on my first impression of this, and go the other way. So Not real often, but because everyone's had the opportunity to write briefs. And those are the main parts of the appeals. That's where the cases are discussed and applied to the facts. But yes, every once in a while, the oral argument does impact. Maybe not in a major way, but in a significant way.
Judge Malone?
We don't judge the cases based upon the eloquence of the oral presentation, if that's what you're asking. You need to have the law and the facts in your favor, or else you're going to lose. I've had cases where only one party showed up for oral argument, and we wound up ruling in favor of the party who didn't even show up because the law and the facts were in their favor, and that's what we try to go on.
I think also if any of you out there are thinking of becoming attorneys, going to law school, and maybe the attorneys here could address this, but I think a lot of people overlook the amount of written advocacy that is done by lawyers. So you really need to hone your writing skills and be able to write persuasively, because that may be the only chance you get to get the judge's attention. And although we see attorneys on TV doing these amazing cases in court and oral advocacy, I would say probably most of their advocacy before a court is written advocacy. And I don't know would you all agree with that, or, I mean, you can disagree. Yeah. Yeah. Yes, ma'am.
So kind of bouncing off the question she just asked, what are your expectations for first-time attorneys or any attorney that's coming in front of the appellate court for oral argument?
That they be prepared, that they know their case, that they have looked at the weaknesses of their case as well as the strengths, and they're ready to respond to those questions. I think you guys were really, really fortunate today. We had some wonderfully skilled appellate advocates today, and they were able to answer questions. You know, they weren't backing down to any, you know, as we tried to point out weaknesses in their case, they were standing firm, and, you know, that's good oral advocacy. So, you know, just to me, preparation is, they need to know that case better than I should not know the case better than they know the case. So, other questions? How many of you want to go on to law school, do you think? Good. We used to have the whole room raise their hands. What? Well, yeah, I mean, paralegals are very, very important to the whole process. Do you all have the attorneys that are here, do you have paralegals? No?
Yes, our firm, we have several paralegals. One of the paralegals has been with the main partner for 30 years. I go to her with questions. She's extremely well versed and very knowledgeable. So it's a critical role in my practice.
Do you guys have paralegals in the appellate public defender's office, or? Yeah. Yes, ma'am.
Now that you've heard these cases, when will the decision be made as to the reversal, if any?
The reversal? They're all going, no, no. Our internal rule with our court is that we will get all written opinions filed within 60 days of oral argument. And I don't have any reason to believe that that would be any different in this case. Now, as you heard when I said sometimes you'll write a dissent and then the panel will switch, and sometimes that there are reasons that delay that outcome, but generally, and I think really our last statistics that we did showed that on average we get the opinion out in about 38 days. So we're pretty, I think, pretty intent on getting a decision and getting it out quickly, not only for the benefit of the parties, but remember, we're then facing the next month of cases. So they have to move pretty quickly. So I would hope that 60 days from today, you'll know what our decision is in these cases. Anything the attorneys here would like to add to the group, or? No? Okay. Thank you very much.